Good morning. Welcome everybody to this meeting of the Interim Joint Committee Judiciary. And we have a very packed agenda today, so we're going to get right to it. Please remember that if you have a cell phone on, to either turn to silent or off, because sometimes it also interferes with the communications equipment. And we'll get started. So with that, we'll call to order. Please call the roll.
Senator Byrd.
Present in the room.
Senator Carroll.
Present remotely from my district.
Senator Kerr.
Here in my district.
Senator Neal. Senator Schickel. Senator Schroeder.
Present from the district.
Senator Stivers. Senator Turner.
Here in the room.
Senator West.
Present in the room.
Senator Wheeler.
Present in the room.
Senator Schroeder.
Present from the district.
Senator Stivers. Senator Turner. Senator West. Senator Wheeler. Senator Schroeder.
Present from the district.
Senator Stivers. Senator Turner.
Well, we don't know. It might play again.
It might revert. You can try.
Representative Banta.
Here in the room.
Representative Blanton. Representative Bratcher.
Present remotely.
Representative Cantrell. Representative Decker. Representative Elliott.
I'm present remotely from my district.
Representative Fisher.
Present remotely from my district.
Representative Hebron. Representative Cole Carney.
Present remotely.
Representative Lewis.
Present remotely from my district.
Representative Maddox.
Present remotely.
Representative McCoy. Representative Minter.
Present remotely from the 20th District.
Representative Mosier.
I am present in the room.
Representative Nemes.
Present in the room.
Representative Petrie.
Present remotely from my annex office.
Representative Scott.
Present in District 41.
Representative Stevenson.
Present in the district.
Co-Chair Westerfield.
Here.
Co-Chair Massey.
Present in the room. We do have a quorum, and we will proceed. So first, I'd like to call for a motion to approve the minutes.
Second.
We have a motion and a second. All in favor signify by saying aye. Aye.
Aye.
Opposed? There's none. We're going to get right to it, and we're going to go a little bit out of order because I've been promised that one of these bills will be very brief, and therefore we're going to let Representative Banta come forward and deal with animal cruelty cost of care. She's coming forward, I believe, last year. This was filed as House Bill 100, if I remember correctly. And she has assured me it will be brief. Plus, I think one of her people had to be out of here at a reasonable time. So with that, Representative Banta, you have the floor.
Thank you very much for hearing this, and I would like to introduce Sherilyn Stevenson. She is a primary sponsor with this bill with me. Talking points for this bill are that it creates an expedited civil hearing 10 to 15 days after seizure. It's separate from the criminal trial. in which court can determine whether animal seizure was lawful and whether the costs proposed by the agency are reasonable. Basically, all this bill is, it's a fair bill for taxpayers, because when animals are seized, taxpayers and the agencies are picking up the cost of care while the animals are being housed and taken care of. So this bill, it doesn't change anything in law specifically. It just adds some things. If a court finds that the agency has met the burden for the removal of the animals, the owner must post bond to cover the costs of caring for the animals, so the taxpayers aren't. Or if the animals are forfeited to an agency, the bond renews every 30 days or until the trial of outcome. It would prevent law enforcement and animal control agencies, as I said, having to bear the cost of taking care of the abused or neglected animals that are lawfully seized. It's fair to the owner and it's fair to the agency. We are only one of 12 states that do not have this kind of law. Kentucky, again, kind of falls behind on this. And we have in your handouts, it shows everyone that is in favor of this, which includes the KSA, the Kentucky Attorneys Association, Chiefs of Police. KACO wants to continue working with us, but they are very, very appreciative that we are looking at the finances in cost of care with this bill. Sherilyn?
I just think that this is something that creates a system that's fair to everyone. It's fair to the owner, it's fair to those who are incurring the cost of care, and it's fair to the animals. So I'm hopeful that anybody here that has questions, we'll be happy to answer those.
Thank you. We do have a question, Senator Wheeler.
Thank you, Mr. Chairman, and I applaud you all for bringing this bill. I just really irks me when I see these people being cruel to dogs and cats and things like that. I guess one question I have, a couple actually, if I may be permitted, Mr. Chair. One, if the person is subsequently cleared of charges, will they be reimbursed any costs for housing the animal?
That's currently not in the bill, but it's something that we're willing to discuss.
Okay, and secondly, if they are, a lot of times, unfortunately, a lot of these people may not have the money to deal with this.
Correct.
I mean, are you proposing like a lien or something to collect it if they are found guilty on property, or how are you actually going to get the money out of these?
Well, they can relinquish the animals, which has happened in a couple different states. So then the animals are adopted out and agencies take care of them that way if the owner does not want to keep it or keep the cost burden. That's just one aspect of it. There's no liens proposed or anything like that. We're just trying to relieve the burden on agencies and make sure that if there is, sometimes people don't go after large animal cruelty or hoarding things because they don't want the cost of care. And this is actually giving them an option to have cost of care should that happen. And also the horse industry is in favor of this.
Well, and I'll hop in here and just say, that is part of the beauty of the fact that they get an expedited cost of care hearing really quickly. It comes down a little bit to personal responsibility. If you have, all of a sudden you have 100 horses that you can't feed. If you can't feed them at home, and then you say you can't provide the upkeep, then at that point, should you really keep them at that point? If you relinquish them and they can then be taken to homes where they can be properly cared for, then that's optimal.
100% in agreement with that, so thank you.
Representative Cantrell.
Thank you, Mr. Chair. I want to applaud you two for working together and bringing this bill forward. I know several of us are big animal lovers in this group, and you talked a little bit about how this is a good bill for taxpayers. It's kind of a good bill all around. Could you go a little bit more into detail about the due process protections and the evidentiary standard that's going to be in place for the expedited hearing, and whether you've talked to our court staff about how they'll be able to manage that?
Well, we believe that the bill includes several layers of protection for the defendant and includes due process. If an animal is seized, law enforcement must post notice that this has happened. Every effort will be made that that happens in person. If not, then it's going to be placed in a conspicuous place where the animal would have been housed. The bill provides the owner with the expedited cost hearing, as we said, so that then it can be determined very quickly who has the burden of the care of those animals as the court case is moving forward. And then finally, the owner will not lose his or her animal without judicial review of the board requested, and they'll also look at the legality of the seizure. So at that point, the burden of evidence is on the seizing law enforcement folks, and the judge will make that determination.
Thank you so much. We've had a couple of very high-profile instances of severe animal abuse in Louisville, and it's just gut-wrenching. So I hope we're able to move and protect our furry friends.
I want to protect our furry friends. I also want to protect our taxpayers.
Yeah, and I'll add there, everybody should have a handout in your packet that talks about some of the costs that have been racked up in Elliott County, over $75,000 for 109 animals that were confiscated from Trixie, over $100,000 for 42 dogs in Breckenridge County, and in Fayette County we had someone who had 135 cats, and the boarding alone was over $80,000.
Thank you very much. We have Representative Nemus.
Thank you, Mr. Chairman. I just wanted to reference that Section 3 of the bill. This is in response to Senator Wheeler's question. Section 3 of the bill requires a bond, so they won't be paying any money other than a bond. And then if the agency fails to meet its burden, the defendant wins, then the bond is returned to the person, so they don't lose any money. And that's in Section 3F. Thank you, Mr. Chairman.
Was this a little familiar to you, Representative Nemes?
Thank you. Thank you for your presentation. If you didn't get the materials, we will get them to you with all the technical issues we had this morning. We just want to make sure all of the information is shared, so we will verify that. So thank you, and thank you for being quick and expedient. We appreciate that.
Thank you.
Next, we're moving on to the thing that is a front and center today, which is the juvenile detention centers. And I believe we have with us Carrie Harvey, the Secretary of Justice and the Public Safety Cabinet, by Zoom, I believe, and Vicki Reed, the Commissioner, Department of Juvenile Justice. And I know that both of them are recent hires, but there was some very disturbing pieces that we all read through stories that came out about things that were going on in our juvenile detention centers. The reason it got put to this agenda today is because Chairman Westerfield and I discussed it. We felt like it was something of immediacy that needed to be heard. So that is what we are going to address today. So with that, if we have those persons on our call, we'll turn the floor over to them initially. I know there will be a lot of questions, so please be mindful of the time. But we scheduled an hour for this process, so you may proceed. There. We don't know if you're muted or not, Secretary Carey or Secretary Reed, or Commissioner Reed, but we're ready.
Okay, how's that?
There you go.
All right, thank you. Sorry about that. I'm Carrie Harvey. I'm the Secretary of the Justice Cabinet. I have with me Commissioner Vicki Reed, who is the Commissioner of the Department of Juvenile Justice. I'm pleased that we can be with you today. I understand that the department has not visited with this committee in some time, so we're happy to be here and to answer your questions. And first, I want to say that I look forward to working cooperatively with all of you and with the committee and your staff. I think working together, we can achieve good things for the kids who are in our care. And I know that's your goal, and that goal is certainly shared by Governor Beshear and Commissioner Reed and me. I'm pleased to be here with Vicki Reed, who is our new commissioner. And as you suggested, we're both relatively new to these roles. I was appointed by Governor Beshear as Secretary of the Justice and Public Safety Cabinet on August the 4th. One of my first priorities was to assist the governor in recruiting the right person to lead the Department of Juvenile Justice. I'm proud to say that we accomplished that mission and that Commissioner Reed and I are continuing the work that was already begun to create a better future for the kids in our care. This is an awesome responsibility and we take it very seriously. We understand just how much is at stake in this work. As Secretary of the Justice Cabinet, I pledge to do my best to foster a juvenile justice system that meets the unique needs of adolescents in our care so that they will become successful members of the communities in which they live. Of course, the best way to address juvenile justice issues is to never have a child in the system in the first place. That's a longer discussion, perhaps for a different day, but it's a discussion that we must have. I want to assure you that Governor Beshear, Commissioner Reed, and I are absolutely committed to the care and safety of the youth of the Commonwealth who are entrusted to our custody. When someone is in our care, they must be kept safe at all times, and that goes for both adults and kids. That's our first responsibility. We firmly believe that one case of mistreatment is one too many, and that we will hold leadership and staff accountable for providing safe and appropriate care for the kids under DJJ authority. As Governor Beshear has publicly stated, we must ensure that we are doing everything right within our institutions in how we care for these kids, many of whom come to us with many needs and in need of help. In addition to protecting the youth under our jurisdiction, it's also a priority to protect the well-being and the safety of our staff, which is our most important asset. Part of that involves revisiting and investing in training and constantly renewing and refreshing our training to make sure that we employ the best practices available and the practices that have been proven by evidence-based research. Maintaining adequate staffing levels has been an ongoing concern in juvenile justice facilities, not only in Kentucky, but all across the country. The COVID-19 pandemic has presented further challenges related to staffing. Unfortunately, this issue can't be solved either quickly or easily. It will require us to think creatively and to invest additional resources in the future of the kids in our care. We are working closely with the Governor's Budget Office on anticipated needs for the next biennium. Those requests are still being developed and reviewed, but we look forward to having additional discussions with this committee as the budget session grows closer. As I said, one of my first jobs in my new role was to help the governor in recruiting a highly qualified commissioner to lead the Department of Juvenile Justice. At the risk of being boastful, I'm happy to report that we succeeded in that task. And I'm very pleased to introduce to the committee our new Department of Juvenile Justice Commissioner, Vicki Reed. On August 16, Governor Beshear appointed Vicki as Commissioner of DJJ with a directive to implement positive changes throughout the department. Since her first day in office, Commissioner Reed has hit the ground running to make positive improvements, many of which are already underway. All of her goals, along with DJJ's entire leadership team, are focused on an overarching theme of providing the youth who are in our care with the education, care, and skills needed to succeed in life. And I would just say that I've known Commissioner Reed for some time, and that she has the two traits that I consider essential for this difficult job. She has great experience and deep understanding of the issues, and perhaps even more importantly, she has a tremendous heart for the work and a tremendous heart for the kids who are in our care. So I'm now going to turn it over to Commissioner Reed to provide you with information on DJJ's hiring procedures, training programs for our staff, as well as the investigation procedures of the Cabinet's Internal Investigations Branch and the disciplinary procedures available if complaints are substantiated. Thank you very much. Again, I look forward to working with you all to create a better future for these kids, and I'll be happy to answer any of your questions at the end of our presentation. Commissioner Reed.
Thank you, Secretary Harvey. Good to be with you all here this morning. Like I said, I am new to this job, but I am not new to juvenile justice. It's been my life's work, and I'm grateful that I've had many different variety of roles to get knowledge from. I started off as line staff in juvenile detention, became a probation officer, and sort of aspired to bigger and better things. And I was able to open an emergency shelter for public offender and status offender kids, and I'm really proud that it's still going 30 years later. I have to say that dates me a little bit. And they're now expanding where they're serving young adults who are homeless, including kids who've aged out of foster care. I started the very first foster care review board in Lexington in the 1980s. It's a forerunner to what we have now. And then in DJJ's infancy, I was very involved with developing the whole regional juvenile detention and alternatives to detention that we have, which got kids out of adult jails. So always, I have tried to put the best interest of kids first. So when I was given the opportunity to serve as DJJ's commissioner, I jumped at it because I felt like I did have something to offer, and I still had goals that I wanted to reach. And I just want to mention a couple of those in the beginning. First and foremost, and to reiterate what Secretary Harvey said, the security and safety of the kids in our custody. And I'll add another term to that. I like to say the safety, security, and well-being. Because I aspire to a higher standard. We shouldn't settle for just the absence of bad behavior, but we want to build competency. Not just committing further crimes, but I want kids who aren't homeless, who aren't addicted, who prosper as adults. We want them to become a participating member of society. So education, workforce development, those are always very high on my list. My other desire is for a greater community involvement with our juvenile justice system, and specifically with we like to call them with our kids. Most people out there don't really know too much about the juvenile justice system, but I found they want to know, and I found they want to help. So all we need to do is ask and provide an avenue for them to do so. I'm also a very big believer in positive youth development. When I talk to the kids in our programs through the years, what always shocks me more than anything is what they haven't done. They've never been on a family vacation. They haven't seen the beach. They haven't waded in a creek. They haven't gone fishing. They haven't played a musical instrument. They haven't gone to summer camp. So we need things not just for kids to say no, but we need things for kids to say yes to. So I think counseling and treatment are great, but I think all those things that our kids have, music lessons, camps, sports teams, that those are important too. The little catchphrase I always have is what's good for kids is good for communities. So when we have those things in place, I think all of us win. So let's talk about Kentucky Department of Juvenile Justice and give you just a little background on that. We serve the state's justice-involved youth with providing the care, education, and skills training to hopefully make them successful citizens. We're also charged with providing prevention services to keep them from coming into our system in the first place. And as excited as I was about taking this job, ideally, I'd like to work myself out of it, and that would be just fine with me. So we have close to about 1,000 employees. We serve youth as young as 10 years old and is up to age 21. We have today, if you look at our latest numbers here, about 239 youth are in our custody, either at one of our juvenile detention centers, which is mainly for pre-adjudicated kids. Our youth development centers and group homes are for youth who've been committed to our care for a longer term. We also have 452 youth in the community. We have community workers that provide for the court, probation services, and also what you would probably think of as parole, but it's for youth who come back from placement and are now back in the community. And finally, we operate 6-day treatments and contract with 18 others to provide education and counseling for kids who are remaining in the community or have returned to the community and are still in their home and can get their services that way. Again, from the first time I came into office, that first week, I started visiting our facilities. I think that nothing replaces actually going out there and seeing what's going on out in the field. So I wanted to listen to staff. I wanted to observe them with the kids. I wanted to see what the kids look like and review our policies and procedures. I've also talked with our community staff, our treatment staff, a whole separate division, our detention alternatives coordinators, just to mention a few of the other people that are involved with our system. And I have to say, one thing I was extremely gratified to find, and I really do want to convey this to the committee, is DJJ is an agency filled with people from our frontline workers, the cooks, the superintendents, all the way through our central office folks, the budget people, human resources, data, the physical plant, who are as passionate as I am about this work. We change lives, we save lives, but it's by no means an easy job. The work can be difficult, emotionally draining, and sometimes physically challenging and even dangerous. The reward is seeing a youth succeed and knowing that we have not just changed that kid's life, but maybe his children's future in the generations to come. So success can be very fulfilling for us. I learned, to no surprise, that COVID has brought staffing challenges, and one of my first priorities has been to address those, looking at some really creative ways that we can recruit and other things that we can do to, more importantly, retain the good staff that we have. We really need to value these people who take care of some of the most at-risk youth in the Commonwealth and provide an environment conducive to the work they do. So we're looking at all sorts of things. We're looking at expanding the use of social media, hiring a full-time recruiter. We're also being more intentional about recruiting from the neighborhoods our kids come from. It's important that our staff at DJJ reflect the diversity of the youth that we serve. And our big message is, and I've stressed this, is that DJJ is a job for people who want to make a difference in the life of a child. And those are the people, if that resonates, those are the people that we want working with us. We do try to be as thorough in our hiring practice as we can. We run a national background check, and we also check for any history of child abuse that there might be on the register. Our staff need to have the education and tools to do their job, so we do take training very seriously. We have 15 full-time staff on our training branch. All newly hired staff are mandated to get 120 hours of training at our Youth Work Academy. That's to meet the American Correctional Association standards. And staff are also required to complete for a minimum of 40 hours of training annually. And I will mention that Kentucky is one of a handful of states where the Juvenile Justice Agency is completely, all our facilities, including even central office as a separate program, are certified by ACA. So training is crucial to our skilled workforce, and we're constantly evaluating ways to improve. Just some of the topics: first aid, de-escalation, adolescent brain development, suicide prevention, and the list just goes on and on. Too long to tell you here. Before I ever set foot in the office, I knew one of my priorities was to examine the use of restraints and isolations. Anybody who goes into this line of work, that's going to be one of your initial things that you're going to look at, with an eye to using both of those as little as possible and as a last resort when other interventions fail. And honestly, I'd love to completely eliminate them, but realistically, there are situations that come up in this line of work when kids are attacking other kids, when kids are attacking staff. And we also serve, unfortunately, a large number of youth with mental health issues. And we have to intercede sometimes to make sure that they are not harming themselves. So these situations are not taken lightly, and revisiting our physical techniques is something that's also on my list. As part of our commitment to ensuring the safety and well-being of our kids, we encourage youth, staff, parents, and others to report any issues or concerns that they might witness or experience. And there's several avenues I wanted to go through for doing this. The first and most important probably is the Internal Investigation Branch, or what we call IIB. And this is located with the Kentucky Justice and Public Safety Cabinet. It is completely separate from DJJ. We have no control over that at all. It's an independent investigating body and composed of members of law enforcement, former members generally of law enforcement. And so they provide us with an outside accountability. Youth and staff at every one of our facilities have access to a hotline that directly accesses IIB. Parents, attorneys, teachers, or any concerned citizen can contact them, including through anonymous letters and phone calls, and they are going to do an inquiry on every single thing that they get. Upon completion of that inquiry, if an allegation or complaint meets their criteria for further involvement, they do have the discretion to refer that back to the DJJ Ombudsman for looking into it and resolving that issue. Some disciplinary things that we can do: staff may be subject to a personnel action from a written reprimand, termination, depending upon the nature and severity of the matter. They might also be required to complete additional training, suspension. So we have a variety of things that we can do. I think this part's very important. Substantiated findings of excessive force or any other serious matter is always referred to law enforcement and the local prosecutor for potential charges, and to the Cabinet for Health and Family Services for possible placement on the child abuse registry. I will say criminal charges are rare, and this has a lot to do with what is determined to be excessive force. We purposely set that bar very high, even if there is no malice involved and no injury to the youth. But if staff does not apply their training technique properly, they can be deemed excessive force. For instance, if a youth is coming at you, one of your first responses might be to push. That would be excessive force. Staff are not allowed to push. They have to go into using the techniques that they've learned. So if they did, that would be an excessive force. In addition to the IIB, there's also a written grievance procedure available. The kids are taught this when they come into intake, and it's also in the resident handbook. The superintendents at our facilities review all incidents and corresponding videos and report any occurrences which may have potentially violated the department's policies. And they are one of the major reporter to IIB. And let me mention these videos. All of our facilities, including the group homes, have 24/7 monitoring. So if someone states such and such happened on such and such date, it's all archived, and we can pull up that footage and look at it. And finally, the youth have access to legal representation. This provides them with a safe avenue to voice any issues or concerns they have. In addition to their own attorneys, we have an agreement with the Department of Public Advocacy. They have staff who routinely come to our facilities and monitor them, and they talk with the youth and care about what they're receiving. Let me be clear and reiterate again what Secretary Harvey said. We take every report seriously. Our employees are obligated to report any corrupt, unethical behavior or policy violation that may affect a youth or the integrity of our organization. They also have an obligation to report violations, including any act which the health or welfare of a youth is harmed or threatened with harm by a staff person. Furthermore, they have to cooperate with IIB investigations, be truthful in correspondence and interactions with the investigators, as well as the completion of any type of work-related documentation. So in summary, I want to reiterate my commitment to providing the best possible services to the youth we serve. The kids that come into our care have seen a lot of trauma in their lives. Parents incarcerated, they've witnessed domestic violence, substance abuse, poverty. We see a number of what we call crossover youth who were part of child welfare, either currently or earlier. The sad national statistic on that is if a youth has had 5 or more foster care placements, they're 80 to 90% likely to touch the juvenile justice system sometime. So some sad statistics that we have. And also our kids come into care with some of the worst physical health in the state. Diabetes, asthma, we have a lot of physical things that we deal with those two. So I'll underscore the important role that DJJ does in providing critical services to the at-risk youth we serve. But I'm also going to state we can't do this work alone, and it really does illustrate the need for investment in after-school programs, positive youth development activities, education, social services, and health services. So I hope we can continue this conversation with you all, and especially when it comes to recruitment and retention efforts as budget discussions get underway. So I'm happy to answer any of your questions, and I'm always open to suggestions of a way to improve our services. Thank you.
Thank you, Commissioner Reed and Secretary Harvey. And I'm going to begin with just a couple of things. I think we all know, well, I know that the committee knows why we're here. There were some reports that came out in September about abuses that had taken place in many of the juvenile facilities. My concern as a chairman, candidly, is that I find out about these things through media attention, not from any reports I've received internally or from your predecessors. That's very concerning to me. Also, I'm concerned that even post those matters, there was no contact with us regarding that. Actually, Chairman Westerfield called me and said, "Hey, did you see this?" And we began to discuss it, but we really haven't had any contact with anybody since then. And this is an important matter. You know, I was in the school business for over 30 years, actually. And I know that the restraints that are used in schools, but I don't see the kinds of abuses alleged there that we've seen here. So that's why we're here today. I'm not saying that either the commissioner or the secretary are obviously responsible, because many of these things happened prior to their appointment, but it is something that must be addressed, has to be addressed, and therefore we are going to have a lot of questions concerning this. So first, I'm going to turn the floor over to my friend, co-chairman, Chairman Westerfield.
Chairman, thank you. Secretary and Commissioner, thank you both for making time and making the presentation there. I share the chairman's sentiments. I'm not here to cast blame on the two of you at all. You're brand new, and the coverage from last month talked about things that have gone on over the last several years. But I do have a number of questions here, and I'm going to try to get through as many as I can. And if I can't get through them all because of time, I'm going to tender them to you in writing and ask that you all respond promptly in writing to anything that I can't get to in committee, because I know we've got another issue on the agenda. So I'm going to jump right in. These are directed to both of you. You feel free. Whoever wants to can swing at the pitch here. How many instances of excessive force are permissible? And let me I wrote these as I read through those stories. Harold Leader had those out, and as I went through, I just thought of questions that occurred to me. And I'm not going to ask about specific personnel issues that you can't get into anyway. I'm just talking about policy and how we run the department. So how many instances of excessive force are permissible before an employee is fired?
That's going to depend upon the circumstance. Obviously, any excessive force that's deemed criminal action is going to be taken is likely going to result in a dismissal. But again, it might be, there's no set number by policy that if there was one, they're gone based on what the circumstances might be. I might share that, again, out of the ones that were talked about in that article, we did look to see how many of those did result in criminal prosecution, and there were two. One, the person pled guilty to unlawful
We lost you, Commissioner. Can you still hear us? Because your screen's gone black and your audio has gone silent, if you can hear us. That was an ill-timed technical glitch. No conspiracy theories here. And now they're gone. Let's give them a minute to see if they hop back in, I guess, Chairman.
That would be fine. This is an important discussion and it must happen.
Yeah.
What we're contemplating doing for everyone that's out there is, if we cannot get them on immediately because of our time constraints, we are asking them to appear. We can go on to the next topic, and we're awaiting their response right now. So if you give us just a moment, we'll see if we get a response. And if not, we will proceed with the next topic and then come back to them.
It's not our glitch.
All right, we have not heard back from them. My understanding, it is not in your set, meaning it's not our glitch. So we are going to move on to the next topic so we can not waste any time, but we will be coming back to this. Again, it is imperative that we have this discussion in light of not only the reports we received, but in light of some other discussions we've had with regards to the Justice Cabinet earlier this month and earlier this week. So with that, we have Ms. Reed, are you there?
I'm hoping.
Sorry about that.
All right. What we're going to do is we're going to give it a shot, and if not, we'll proceed to the next topic and circle back around with you for today. If this doesn't work, we are requesting that you come up and make an appearance, be in mask or whatever need to be, but we want to have that discussion today. So if you're ready to proceed now, we'll continue. But if it breaks down again, we're going to move to the next topic and then circle back around to you, and we hope that you'll come join us so we don't have these technical problems. With that, you may answer the question. If you need Chairman Westerfield to restate it, he'll be glad to do so.
I think I remember the question.
I do. Again, as far as I know, and again, I am new on this and still learning myself, but there is no policy about on the second or the third, but obviously we would look at that. We look at everything, we're constantly monitoring. Part of it would be, was this person a 20-year employee and he had a excessive force 15 years ago and now he has another one. You're going to look at the seriousness, whether the person's on probation on the other end of that spectrum and has already had one. So anybody who would show a propensity for that would certainly be looked at for possible dismissal.
Is there a policy that differentiates between substantiated and unsubstantiated?
As far as?
Well, I would think if you cannot.
In terms of disciplinary response.
Yeah. If you don't have good reason to believe that the incident actually happened, then I don't think you would employ any discipline. But I would also say that, we don't operate like someone in a private business with at-will employees operate. We operate within a statutory framework for dealing with state employees. And obviously everything that we would do is circumscribed by that framework. And then the last thing that I would say about this is it depends, of course, on the specific facts involved in a case. And one of the unfortunate aspects of kind of using shorthand and saying, well, there's this many substantiated cases of excessive force, not all cases are the same. And as Commissioner Reed explained earlier, you might have a case where an employee who was being attacked by one of these kids just reflexively and defensively reached out and pushed the kid away. Well, that would be a violation of that staff person's training and would be called excessive force. And that should be dealt with, and there should be some corrective measure taken. But that obviously, and we would all agree, is much different than if we had a staffer who just intentionally tried to injure a kid. So there's no way to say it takes this many instances.
I appreciate that, and I think that's a fair response because every situation is different. Can you if you know or if you don't know, is there a policy with regard to discipline of an employee that differentiates between, is it written somewhere? You've got something that kind of, or that describes it in a substantiated case of excessive force. Is there any sort of, I'm sorry?
No. Again, I think the thing on those is that any excessive force, like I said, goes automatically to law enforcement and the prosecutor's office, and everything goes up channel. Like I said, our superintendents look at every restraint that happens in the youth development center or one of our group homes or day treatments. That video is reviewed by the superintendent.
Thank you.
If they see anything, then they're the ones that, where if somebody didn't do what they were supposed to do, they're the ones that are generally contacting IIB.
One of the stories mentioned, and it quoted that in the supervisor's notes, an employee's decision making was, quote, horrible and, quote, haphazard. Are those notes following an incident reviewed by? You just mentioned that everything goes up, but are those supervisor notes, are they reviewed by upper management or approved or followed up on, even if it's an unsubstantiated case of excessive force? Is there someone above supervisor level at the facility that's reviewing those notes?
I think our staff are always aware, and again, with every restraint, as soon as it's over, the youth is observed, and if it's there in the daytime, they're looked at by the nurse. People are aware when that happens. They have to report every restraint. It's in the monthly reports. We follow that. We have charts and so forth, and we do look for. Let me
ask to clarify, Commissioner. Sorry to interrupt. When you say use of a restraint, are you also referring not just to officially sanctioned Aikido type restraint protocols, but also potential excessive force instances, both? All of those instances, or just the quote-unquote official ones or proper ones?
We're reviewing every restraint.
Okay.
That there is, whether it was done properly or not properly. We look at the video of every one of them.
Another former employee in a different instance was quoted as saying, quote, all we are doing is quite literally keeping them in a cell and praying for the best, quote. Are there any juveniles that are kept entirely in cells that way, without programming, without treatment, without schooling? Are there any that fall? Do you dispute that quote? Or would you care to correct it?
No, I will dispute that quote. I mean, we have policies and procedures for if a youth does go to isolation, how long they can be in there,
right?
All the way on up to our medical staff. And generally that's kept a very short time. I will say that if we have found circumstances where because of issues, say a brawl on the unit where kids go into their rooms for a period of time, that does happen. But we do make sure that they still get their services, that they still get education, they still hygiene, they still get to contact their parents. So they, we're not locking kids up away in cells.
What is the limit on isolation? Number of hours?
For the amount of time?
Yes, ma'am.
I don't have that right here in front of me for all the specifics of it. I know it starts with 2 hours and then it goes up to, the supervisory approval, then it goes up to regional facilities manager, it goes to the deputy commissioner. With each extension, somebody else further up the chain has to be notified.
There was one instance in another case that was reported where a juvenile was kept in for 43 hours. I wonder how many levels of approval that obtained or whether or not they were obtained in that case, but that's well outside 2 hours or any reasonable extension of that. How many and I don't know the answer to this question. I don't know the answer to any of these questions. Internal Investigations Branch, Mr. Secretary and Commissioner, you said that this is part of the Justice Cabinet. Does it only review DJJ matters, or does that branch review other agencies within the Cabinet?
It primarily reviews DJJ matters. It is attached to the Office of Legal Services, and its primary function is to review DJJ matters.
Do you know how many it's reviewing on an annual or a monthly basis?
I don't know, sir. I don't have that number, but if we can make some notes here, we'll try to get you an average or the last couple of years, however you would like to.
I appreciate that. How often are Kaido maneuvers utilized on a monthly or an annual basis? I understand that, or Aikido, I've heard it pronounced both ways, and I'm sure I've butchered it both ways. They're obviously used in your facilities, I would venture to say every day, but isn't it also true that that's reported? Yeah, I think you've already mentioned that. One of you has already mentioned that. So do you know how many instances of that are used on a statewide basis annually?
I don't know the number of restraints. I do know the number of restraints. I don't know because Aikido does not always involve a restraint.
Sure.
One of the maneuvers is escorting a youth safely, like a youth refusing to move. There's a way to hold to take the youth, and so all of those moves that they do are not reported.
How many instances of restraint are used annually, on average?
I don't have that number in front of me.
I thought you just said that you did have the number of restraints. I apologize if I missed
Well,
it.
we keep it. I just don't have it in front of me.
Got it. Fair enough. Fair enough. I can't believe you don't have that off the top of your head, Commissioner. All right. Is there a written policy against using racial slurs in the department?
Absolutely. And I will point out that incidents that was in the newspaper, not that it makes it any better, but it was a black staff who was using that on the youth.
Yeah, that does not make it any better.
No, it does not. I completely agree. But he did receive a 10-day suspension.
I believe the paper reported perhaps a 12-day suspension. What is the consequence? Is there a stated consequence for using racial slurs?
I think that goes into a broader, use of how we deal with kids and so forth. I don't have the exact policy here. There's lots of policies.
Okay. Is there when raises are given to staff, are considerations given to prior conduct or their behavior while on staff, or are they given categorically?
I don't think we get many raises. I don't think
not you, and let me say you don't get enough.
I'm
be the
not
first
sure.
to tell you that, along with just about every other agency in your cabinet and just about every other agency in just about every other cabinet. But that's for another time.
I think the only way we have to do that are ACE awards, where we can give a small thing for somebody who's done above and beyond. But that otherwise, the conduct is, usually it's across the classification, whether all youth workers or all superintendents, and it's not individualized.
When increases like that are approved at the upper levels of the executive branch, does the department not have the authority to deviate from that on individual cases?
I'm not aware that we would.
Okay, thank you. What is the department's policy for informing parents or guardians of the incidents on campuses in these facilities?
I need to research that.
What is the department's policy for informing counsel for incidents on campus?
I'm not sure that we do that.
Even with that partnership with DPA, the attorneys aren't informed, the ones that come to the facilities, or do they just walk in and get the news when they show up?
I'm going to have to fall back on being 6 weeks into the job on some of this. I'm sorry. Some of this I'm going to need to research.
I understand. What is the consequence for staffers that leave a facility unattended?
To just walk out?
Yes, ma'am.
I would say they're fired. Abandonment of duty, or at least we would try. We would, and again, we would send that up. The personnel board might be involved in that, but generally, if somebody abandons their post, then I would think a dismissal would be in order.
One of the alarming parts in one of the stories was described as a riot at the McCracken County facility, and that's one I'm familiar with. I've been to it. I've dealt with cases of juveniles that are housed there in my days as a prosecutor. That there was in the summer, and I forget which year this was, that there was that staffers just left their post. In fact, Not only did that happen, but it happened again or previously 3 weeks prior to that instance. And in both cases, in both situations, staff left some children there unattended, the ones who weren't involved in the riot or in the uprising that was going on, but they left some youth just behind. There was a quote from one of the staffers that said, quote, she, quote, did not know what she was doing, nor did other staff know what to do, close quote. Are your staff trained on these riot-type scenarios?
They are. Riots and hostage situations is one of the topics that they're taught. I will state that the one employee that, like for the one that got their keys, it was their second week on the job. So it takes a while sometimes to develop some expertise.
And let me just say, I want us to be very clear on this. If that happened, that was before our tenure. I know it was reported, and I just don't have a way to, I haven't researched the accuracy of that. But if something like that happens, that is obviously completely, utterly unacceptable. We would find it completely unacceptable. And if that happened, I can assure you, we would use all the tools available to us within the statutory personnel framework to take disciplinary action against those involved. So I don't want there to be any misunderstanding about that. We would not have any tolerance for that sort of failure in our department.
I appreciate that. Is there a written protocol or guideline or policy in the department for which police agency or whether a police agency assists in regaining control of a facility like that? Is there, even more broadly, is there a policy at all for what you do when a facility has become overrun and you no longer have control over it?
There are policies for when law enforcement would be notified. And I think particularly in that instance, one of the things was that one of the youth seemed to have had a piece of glass that they'd gotten and made into a shank. And so that there was concern for staff beyond just being able to do a physical restraint.
Sure.
One of the things to recall on this with our folks, and this is very different than many juvenile justice agencies in other states, is we don't have pepper spray. We don't have restraint chairs, spit hoods, all of that. Basically, we have our staff and say physical management, and beyond that, then we look at law enforcement.
I'm curious also about whether or not this policy exists and what it says, because of the two reported incidents, both there at McCracken within the span of about a month. State police responded to one, Paducah PD responded to the other to help retake control of the facility. I'm curious why one was utilized in one instance and the other in another. I mean, you're still a good ways away from post one, or whichever post. I've got post 2 in Madisonville, but
yeah, that'd be post 1 in Hickory. Yes,
but you've got a ways to go from post 1. But Paducah PD is pretty darn close to the facility. I'm just trying to get a feel for what's the written policy for what you do when this happens, if there is one, and if there is it functional, and why did one agency respond one time and another respond the other time?
I don't know the answer to that. And, again, I don't know what's in the policy. We'll look at that and we'll get you an answer on that. Sometimes, as you know, it could just be the nearest available law enforcement unit to be first on the scene, or it's possible that the staff just called one agency or another.
Sure.
But we'll look to see if there's a policy that says call the local municipal agency or call the state police, and we'll provide you with that.
I appreciate that. One of the most troubling, it's the most troubling that was reported in one of those stories, was the conduct of 2 employees who observed nude female juveniles. Said that charges were referred to, or potential charges were referred to prosecutors' offices, or perhaps I asked myself whether or not they were. I don't recall if the story said that or not. But that's a criminal act at at the least, just based on what was in the coverage in the news piece, at the very least, it's a voyeurism charge, which is a Class A misdemeanor, and based on the dates, might still be viable for a criminal charge. And I think it could also meet promoting a sexual performance by a child, which, depending on the age of the child, could range from a C felony to an A.
I'm sorry, this one I can respond on. We did view
Please.
that, and that did not happen. At no point in time did the staff see the girls when they were naked. It didn't happen. We have it on video and we can see.
Well, I'm relieved to hear that, but then I'm confused that the story mentions actually part of the point was that one employee was terminated shortly thereafter, and the other one stayed around, employed for a time, might still be employed. I don't know. So I'm glad to hear
sometimes
that
staff resign for a number of reasons,
Sure.
including the fact of being in an IIB investigation. Some of them, the pay is low, and then when some of this starts to happen, they sometimes do leave. But we did have staff and IIB review the video on that to see if that happened, and it did not.
I appreciate that. There are a couple other folks that have some questions. I've got about 15 more that I'm not going to ask you here, but they relate to the use of psychotropic medication. Again, the use of isolation and limits on isolation, the staff to youth ratio in each facility today, whether or not staff are supposed to respond to medical requests, whether or not staff are permitted to hear calls outside the facility if those calls are recorded, just like they are for our jails around the state and in our counties. If there are time limits on those calls and how they're enforced, and whether or not staff are charged with responsibility to intervene in physical altercations, and if they are, or when they are. So a number of additional questions, and I'm going to submit these in writing, and I would ask that you all tender an answer in the next 2 to 3 weeks back to the committee with your responses. I appreciate your help today answering the questions that you could. Thank you, Chairman.
Thank you, Chairman Westerfield. And I'll add to that list with him. We'll probably send this jointly. Another question that I would have just to think about before we move on to the other questions is what policies or procedures do you have for notification to parents when something like this occurs? I'm not going to ask you to answer that right now. I'm going to move on to Senator Wheeler.
Thank you, Mr. Chairman. I read this article, and I can think of no circumstance where the use of the racial language is appropriate. I was also disturbed by the story about the new female girls, and I'm very happy to hear that didn't happen. But as far as many of the other instances, though, I was somewhat sympathetic to the guards here because I think there was no context given in this Herald Leader article. We don't know how large the youths were. I mean, my son plays on a little league football team and is in 5th grade, and we have kids that range from 60 pounds all the way up to probably 150. I mean, there's a few kids on there that could take me down in his age. So, I guess what I have concern about is, it was mentioned here today, if a kid runs at you and you push him off, that's considered excessive force. I mean, what do you expect these people to do? I mean, I've actually had, just speaking with Senator Turner, I think I've represented a claimant that's been injured by youth before in a workers' compensation claim. I know that he has as well. I don't think you can necessarily just expect people to stand by and allow themselves to be severely injured, because I'm sure some of the kids in these facilities are maybe mentally are not appropriate for an adult facility, but physically might not look out of place in an adult incarceration facility. Is that not correct?
That is correct.
And I think you're right. There are children who are in a grown-up body and they can hurt you. And in answer to what we would expect them to do, and I appreciate your point. I mean, we care about our staff and our staff on any number of occasions have been injured. I think what we can fairly expect them to do and demand that they do is to adhere to their training and to not deviate from the training And then it's incumbent upon us to make sure that the training is appropriate and that we're constantly making sure that they have the right training in how to deal with those situations. But again, not every situation is the same. When it's somebody just pushing one of the youths away to defend themselves, I mean, I certainly wouldn't think it'd be appropriate to terminate that employee. It might be appropriate to do more training. On the other hand, if somebody is intentionally hurting a kid, then that person needs to be fired and prosecuted to the fullest extent of the law. So every one of these situations occur in a factual context that dictates what an appropriate response is.
And just a brief follow-up. I mean, of the incidents, I'm assuming you've seen the article that it was provided to you beforehand. You know, is there some additional context? I think we already know, at least in one case, there was the incident that Senator Westerfield mentioned about the girls being nude. You said it did not happen. Clearly, the paper didn't mention anything about that. To what degree do you think that the incidents described herein have been sensationalized by the press?
Well, and let me say this: we're not media critics, so we're not going to critique the reporting that is done. And in some cases, reporting can be useful to bring to light things that might have been unknown. But I think with some of these incidents, there probably is additional context. Can you speak to that, Commissioner?
There is, and we did. I did get a report. Again, all of these happened before I came in, but we did get a more list of what happened with those, and we've reviewed all the videos to see. And as I was mentioning, right when we cut off, out of all of those cases, 2 were. I'm not sure how much of you heard. 2 were referred for. Well, all of them were referred for criminal prosecution. 2 were thought that were done. One, the staff person was pled guilty to unlawful transaction with a minor and official misconduct. On the other incident, the person was charged with assault and he was acquitted in a jury trial. So those out of all of those cases, two were prosecuted.
And I think it's mentioned, I think they said 116 incidents. So out of 116 incidents, 2 actually resulted in criminal prosecution.
Yes.
Thank you, Mr. Chair.
Next, we have Senator Schickel.
Thank you, Mr. Chairman. I don't really have any questions. I have more of a statement I want to make with your permission, Mr. Chairman.
I'll do it.
First of all, Commissioner Reed, I want to welcome you to Kentucky, and I've enjoyed listening to your testimony. And I can tell from your testimony that you have a passion and a love for what you do. I think I'm probably maybe the only person in this room that's actually run a juvenile detention facility. I remember back when counties had juvenile detention facilities, and I was the jailer, and we ran the juvenile detention facility. And I thought we did a darn good job of it back in those days, and Kentucky Youth Advocates and the Children's Law Center sued us, and they wanted us to have these facilities that we have today, and they thought all our problems would go away if we just did that, and so we did do that, and here we are today. I want to talk about what I call real life, because you have a tough job, Commissioner, but especially your employees have a tough job, and I want today to stick up for them. Because for me, this article that was in the Lexington Herald was completely one-sided. It was a hatchet job, and it was out of context, as the other senator said. There was no context provided for the article. I want to reflect on just a few things. First of all, a 16 or a 17-year-old can be very powerful, very powerful. And if a person abandons their station, and I've talked to several of these detention officers myself because I was so interested in it, they were in fear for their lives. And when a detention facility is taken over by force, and we're asking the question, were any of the guards fired or disciplined? But nobody's asking the question, was there any additional charges to these juvenile thugs that were trying to take this place over and doing this riot. And I would like to ask you, Commissioner, was there any charges filed?
I didn't get the information on that. Routinely, that does happen if there is actually an injury to someone. If it's not, it may not have. So I'd have to, again, that happened. I'm not sure what year that was, but I'll,
Well, I'd be curious to know, and in interest of time, if you could maybe get that to me offline, I'd appreciate it. I also think that we need to revisit, when we talk about policies and procedures, I'm not so sure that it's prudent to remove pepper spray and restraint chairs from a juvenile facility. Not that they should be used very, very sparingly, but I have to ask myself, what alternatives does a guard have or a correction officer have when someone is using powerful force against them? And I almost have to laugh when I see that the Kaido is the approved method. Anyone that's ever been in a knockdown, drag-out fight, fighting for their lives, know that you operate by instinct. You don't have time to go to a 20-hour seminar that you learned Aikido, which I've been through those seminars, but you go to your instinct to defend yourself and to defend other people. And then you have somebody watching a video the next day or 2 or 3 days later that's probably never been in a fight in their life, deciding whether you use too much force or not. Just put yourself in that situation, and this is an incident that happened at 3 o'clock in the morning, and you're being paid whatever they're paid. It's almost nothing. So I don't want to say they did everything right, but I do think someone needs to stand up for them and say, we put these folks in a very, very, very difficult situation. And now we are looking at it, and we're not doing it. We're home in bed, but we're expecting them to do everything right with people who are 16 and 17 years old, like the secretary said, who may have the mind of a child, but have the body and the force of a very, very strong adult. Thank you, Mr. Chairman.
Thank you. We have about 3 more questions. I'm going to ask those participants to be expeditious questioning because we do need to move on to the other matter. I know we had technical difficulties, but I want you to be mindful that Chairman Westerfield and I are going to submit written questions. So if you have other questions, we can also add that to our questions to be submitted. So next we have Representative Bratcher.
Thank you, sir. Commissioner Reed, several times you alluded to video. What is the policy with the video? Are 100% of the interactions between the staff and the juveniles on video? And then the second part is, how can somebody access that video? Is it an open records deal, or is it closed, or how could somebody like me, for example, see these videos?
I can answer the first part on that. Yes, pretty much just about every inch of the facility is video. The exception would be bathroom areas and shower areas for obvious reasons. But we can actually tap in at any time and see what's going on in real time in the facilities, and we can archive. If somebody says something, we can pull it back up, and that's a routine part of the IIB investigation. And I am not aware of the procedures for anyone beyond IIB and internally to do those. I'd have to look into that.
Thank you.
Next we have Senator Turner.
Thank you. Excuse me. Thank you, Mr. Chairman, and thank both of you all for being here today. Just a few questions. We've all seen these prison riots by adults, and I would like for you all to provide the information of the total incidence of injuries to your employees in this. I've, like Senator Wheeler, have represented a big 6'4" fellow that had been in the military that was one of these facilities and ended up getting his knee damaged so bad he got totally disabled after he got tackled with some of these couple of these young men at a facility. So I'd like to have the statistical information provided to us of the incidents that affect the employees. And I don't know how you want to do it, but I would like to have that. And how many of them had to get workers' compensation claims? As I understand it, they are state employees, as you said, and they have the right privileges that apply to them whenever they're cited or charged with some offense in this, and try to get the number of staff that are present when you have one of these riots, and how many of your staff have gotten injured in sometimes of these riots. That statistical information, all that you can give us, I'd appreciate it. I'm trying to shorten this up because of the time. Thank you, Mr. Chairman.
And I would say I do know that we, as I mentioned earlier, it happens that there are staff who are injured, and I know we've had some workers' comp claims that have been produced from that. And just to go back to the last question about the video, I believe that we would routinely deny an open records request for release of those videos for a couple of reasons. First, there's obviously a lot of sensitivity around identifying children who are involved in the juvenile justice system. Those records in the courts are confidential, and the same would be true inside one of our facilities. And then also just with any detention facility, whether it's youth or adults, there's always security concerns about releasing video from inside a facility. So I think that video is typically not available.
Thank you, Mr. Chairman. That's all I have.
Thank you. And we have one other question. Senator Berg.
Thank you, Mr. Chairman, and thank you for presenting today. I think I'm a little confused because, intuitively, in my mind, it would be, absolutely zero policy for excessive force. But then it seems like in your excessive force policy, you're including things like putting your arm out to protect yourself, which wouldn't, in my opinion, be included in excessive force. That would be a reasonable response to an unreasonable situation. So I guess I'm asking, could I see your excessive force policy in writing? And could somebody explain to me down the road, not now because of time purposes, why things that would be considered basically a normal reaction are included in your excessive force policy? Because that, to me, that's not excessive force, and excessive force should have a zero tolerance. So if we're going to have a zero tolerance, let's have a policy that makes sense for a zero tolerance policy. So thank you, and I'd really like to see that in writing. I appreciate it.
Thank you, Senator. And I will thank the Secretary and the Commissioner for a presentation that I know was difficult, especially given the circumstances that they are relatively new and they inherited situations that were already there. We want to help you, as we've asked before in some other different meetings, help us help you. So tell us how we can help you to deal with these situations from an accountability perspective. We simply want to make sure that these situations, if they've occurred and if they're problematic, that we address them, because we believe we owe it to our constituents and to the taxpayers to do so. So thank you for your presentation today. We do look forward to working with you, and thank you for your time.
Thank you.
Thank you.
Okay. With that, we're going to move right on, and I will tell everybody here, because of the technical difficulties, and we do not have to vacate this room, we are going to continue with our next presentation, which is on medical marijuana. Or medical cannabis, I should say. We've had this before in the House, and I know that there's been discussions in both chambers. And so Representative Nemes is here today, and we also have somebody, I believe, from KMA that, are they on there? Or is it UK? University of Kentucky. It's, how do you say her last name, Representative Misher? Babylonis? Okay. Is Miss Babylonis here? Miss Babylonis, in light of time, we actually are going to afford you the opportunity, since you're by Zoom, to go ahead and present. We don't want to tie up you any longer than we have to. We know that you're busy doing the things at UK. So if you would like to go ahead and provide commentary on this proposal about medical cannabis, we'd be glad to hear from you. So I hope I didn't butcher your name. I believe it's Shanna Babylonis.
No, you did great. It's
Right.
Shana Babylonis,
All right.
and I'm an assistant professor at the UK College of Medicine, and I do a lot of cannabis and cannabinoid work in humans and also do a lot of physician education around this topic to try to inform physicians about the science behind cannabinoid and cannabinoid medicine. And so if I had to give a few blanket comments, my first would be that I'm just a little bit concerned about a wide-scale rollout of a medical cannabis program in Kentucky at this point. And the reason that I say that is that I'm worried that our physicians are a bit unprepared to handle the patients that come to them asking for medical cannabis, because the science is just not up to speed with what we need to be able to recommend a specific dose, a specific strain, a specific condition that warrants medical cannabis. So in a lot of my work, I keep up with the medical literature and try to help inform physicians of those appropriate recommendations. And unfortunately, at this point, outside of palliative care, which means like end of life care, we're really limited to understanding any specific dose that we can recommend, the frequency of that dose, what specific strain or concentration of THC or CBD that we should be giving folks, and for what conditions medical marijuana may help or hurt those conditions. So I would just urge this group to really consider having a roundtable with leading physicians, leading scientists in the state to talk about some of these issues. For example, there's not a widely accepted cutoff for driving under the influence of cannabis. So there's not a national standard for that level. And it's state by state patchwork laws. And so that's one thing that Kentucky will have to grapple with if it moves forward with medical cannabis, is coming up with one of those cutoffs with expert advice. Also, what conditions are we willing to treat with medical cannabis? Some states will allow treatment for any condition that the physician warrants can help with, medical marijuana can help with. Other states have a list of qualifying conditions. Sometimes those lists are created in a way that don't involve scientists and physicians with their input. And so I would just encourage this group to engage the scientific community and the physician community in Kentucky to help inform some of these decisions. And I'm happy to take any specific questions as well.
Thank you very much, Doctor. I do know that Representative Mosier has worked diligently to work with research concerning cannabis, and we certainly appreciate her efforts on that front. We appreciate you. We do have a couple of questions. Senator Berg.
Thank you very much. I have a question for Dr. and I don't want to pronounce your name wrong, Babionis. 36 other states have already legalized medicinal marijuana in the United States. Why do you think Kentucky, being one of the remaining 14, if I'm doing the math right, why do we have to be more cautious than everybody else? I'm not sure I understand your point at all, and I'd really appreciate some clarification on it.
Sure. So I'm just giving my perspective. Obviously, I'm not a legislator, so it's not my decision whether medical cannabis comes to Kentucky or not. But one of my major concerns about cannabis is its interaction with the opioid crisis. So a lot of times we're hearing in the media that medical cannabis can be a cure for the opioid crisis. And the data just don't bear that out. And Kentucky, as you know, has bared the burden of the opioid crisis more than other states. We're just really acutely sick compared to other states. And so some of my research is trying to find out, what does cannabis do to opioids? Does it make someone primed for an overdose? Does it protect someone for an overdose? Does it not do anything? Those are the kind of answers that we don't have, but would affect Kentucky specifically. So that's just one example. Another example is talking to physician colleagues. They come to me and ask me for advice. What conditions are well known and well established? What clinical trials have been conducted that have shown cannabis efficacy for a certain disease? And I can give them a list of very, very few. And so we're asking physicians to be in this position of prescribing or recommending medical cannabis, but without the clinical trials that they would like to rely on to see what doses should they recommend, for what conditions should they recommend. And so they're flying a bit blind, as is the rest of the country. And so it's not a problem unique to Kentucky, that problem, but it is a problem.
Okay, thank you. Thank you for your answer. And just in follow-up, I mean, my understanding of the situation, I have not done personal research on cannabinoid at all, other than reviewing the literature that's available. Here in the United States, because of the schedule of the drug, we've had problems doing good quality medical research.
You do not have to tell me that. I completely
Right.
understand that and all the bottlenecks. Yes.
Big problems. And I'm actually wondering how at University of Kentucky you're actually being able to do research, because my understanding is it's not even allowed at this juncture. But we do have research from other countries.
No, it's permitted in the United States, and I do it right now. So I have a DEA Schedule I drug license to be able to house and administer marijuana to human participants who qualify in my studies. All of my work is funded by the National Institutes of Health and the National Institutes of Drug Abuse. And so right now, the kinds of things that we're doing at Kentucky are looking at how does cannabis affect driving behavior. So we have a driving simulator in our laboratory, and we're doing very controlled studies to see, to answer that question compared to alcohol. So we know alcohol is impairing, but when you put it head to head with cannabis, how does that look? What should we look out for? Is it impairing across a dose range? Other studies that I'm doing is to try to figure out how cannabis interacts with opioids. So does it make opioids more dangerous? Does it make opioids more abusable? Our preliminary data say that cannabis does make opioids more abusable. So that's a concern for Kentucky that I think that we have to talk about. So we are doing that work. I also have grants in motion to look at how cannabis can affect opioid withdrawal and opioid reward in those with opioid use disorder. So folks who are getting sick when they stop and who we would call addicted to opioids, just to further kind of address how cannabis can modulate the opioid epidemic. And then I'm also writing a grant to look at how we can treat cancer patients with cannabis. We don't know the specific doses that we should look at. We don't know if it interacts with their chemotherapy treatments. And so all those studies I'm doing right now at UK or have proposed to the NIH.
Thank you. Thank you very much.
Senator West.
Thank you, Mr. Chairman. Couple quick questions. The first one deals with the clinical trials. You mentioned we don't have enough clinical trials, and I've heard a lot of talk on not enough phase 3 double-blind studies on this. In your opinion, how long will this take before we get the information you're describing as far as clinical trials in the United States?
That's a really good question, and it'll take a long time.
Okay. Second question deals with opioid use. I would be the first to agree with you that cannabis will not cure the opioid epidemic. I don't think anybody would think that. But clearly there is some evidence out there, and if we study other states that are currently allowing cannabis use, that it can possibly help. And for instance, in Colorado, I believe after legalization, their opioid use declined significantly. In your opinion, is there information out there showing that legalization of medical marijuana can help with opioid consumption If we decrease opioid consumption, wouldn't that be a good thing?
It would be amazing. I would be the first person to stand in line and broadcast that data as well. Unfortunately, the data just aren't there right now. So Colorado, their overdose death rates have remained high, and despite legalization. There have been several large-scale studies that have looked at across time, so like a kind of a time capture analysis of when states legalize cannabis and what does it do to their opioid overdose death rates. And so a study came out quite a few years ago that made the headlines that said in states where cannabis was legalized, the opioid overdose deaths decreased by about 25%. And so that caught national attention, and it was very intriguing. What that study really looked at was just a correlation between a law and a death. It wasn't saying that people who took cannabis were more likely to survive. They didn't do those toxicology analyses. It was just saying in these states at this time, there was less deaths. Since that study came out, there's been a study in a really highly regarded journal, the Proceedings of the National Academy of Science, that have reversed that. And it says in states that have legalized medical cannabis, opioid overdose deaths have increased 25%. So it's a correlation though. We're looking at a correlation between two things. It's not an exact causal relationship. And so what we really need to look at is on a pharmacological basis, what does cannabis do to opioid respiratory depression? So does it make someone have worse breathing? Because that's how you die of an opioid overdose, is that your breathing slows down to the point that you stop. And so our work is trying to figure that out exactly under really controlled conditions. There's a lot of survey work as well that'll say, we've surveyed patients who are taking medical cannabis and they're reporting that they're taking less opioids. But when you drill down and do a very carefully controlled study and look at things like a Casper report to see, are they actually filling less opioids? Are they actually getting prescribed less opioids? We don't see that bear out. Again, I think part of it is because the science is in its infancy and we need more research. But if you ask the question, is there convincing data that cannabis can help decrease opioid prescriptions or opioid overdose deaths? The answer is no. There's no convincing data.
One quick follow-up, Mr. Chairman.
You may proceed.
Thank you. Out of curiosity, that study that you mentioned from the Academy, was that the beginning of the COVID pandemic or before? Do you know?
I believe it was before.
Okay.
And things have only gotten worse since the pandemic. As you know, overdose deaths have increased.
Absolutely. Thank you.
Senator Mosier. Senator, Representative Mosier. I didn't mean to either promote or demote you. So.
Thank you, Mr. Chair. I'm not quite sure what to say about that, but thank you. Dr. Babylonis, thank you so much for being here. I have great respect for your work. I know that you have spent your entire career really researching cannabis and know a great deal about it. So I really appreciate your being here. I think that your even keel approach to this really is really helpful, because there has been so much emotion around this issue, and I think that you and I agree, at least that more research really is necessary to really understand medicinally what cannabis can or can't do. You've kind of run through what the guidelines are, or the lack of guidelines that we have in place for the medical community, and it really seems that public opinion and the popularity of this issue is getting ahead of where the research is. Can you talk a little bit about, you've talked a little bit about the difficulty in research and the speed with which these clinical trials move, but what are some of the current research that UK is doing on cancer treatment or the symptoms of chemotherapy, for example? I know that you've got some grants that you're applying for to work on this research. I guess one of my questions would be, would having a center for research specific to cannabis, would that help expedite some of these clinical trials and FDA approval processes?
Absolutely. I mean, the science is just not getting done because of some of the barriers that we have discussed earlier, having to need a Schedule I drug license, needing FDA permission to conduct these studies in humans. So some compounds we just can't study. So there's Delta 8 THC that's being used in an unregulated way right now that we can't study because of FDA limitations. And so some of it is just we can't get the work done because of these bottlenecks, but we can get a lot of work done when it comes to medical cannabis. So if we had a organized center and like a brain trust where we could work together, a group at UK could work together to fast track the most important studies, I think it would be huge. So there haven't been, surprisingly enough, there haven't been very well-controlled, placebo-controlled, randomized trials to look at how does cannabis help cancer patients? What facets does it help? Does it help them sleep? Does it help their quality of life? Can it help their pain? Can it help them reduce their opioid use? And so that's one of the grants that we're applying for right now, is to really look at that in a careful way and without an agenda. I'm the first person to say, if cannabinoids can help people, which I believe the marijuana plant, the cannabis plant, is a treasure trove of medicine. I truly believe that. I just think that we have to tap it in the right way, and we have to be careful about it. We know that there are some conditions that cannabis makes those conditions worse in some people. It can make seizure disorder worse in some people. It can make it better in some people. It can exacerbate Parkinson's disease in some folks, and it can alleviate it in others. And the last thing we want to do as a scientific or medical community is to make somebody feel worse because we don't have enough science behind it. And so I think that if we had more research and we had more focus of what are the most important questions that we need to be asking, and we had the scientific expertise to do it in a controlled and unbiased way, it would really help move the science forward.
Okay, thank you. One more question, if I may.
Yes.
And this might be a really basic question. We know that there are a lot of compounds in the cannabis plant. Are CBDs as valuable, or is there valuable medicinally, or is it just the THC component?
So there is therapeutic efficacy with CBD. There is an FDA-approved product now called Epidiolex that is pure CBD that's approved for the treatment of 3 types of intractable seizure disorders. And it's being explored for probably every other condition you can think of as well. It's a really popular compound, and people are really interested in it. THC is also approved by the FDA in a few forms. It's synthetic forms to treat cancer-related, chemotherapy-related nausea and vomiting. Whole plant cannabis, though, we still don't have a good indication for what that might be good for. It could help with seizures. It could help with cancer patients, but those trials haven't been conducted. And so aside from THC and CBD, that there are signals that those are effective medicines, there are probably 50 plus other compounds in the plant that we're also interested in, that we're starting to isolate, that we're starting to look at. And so, again, I think that the whole plant can work together and do different things. So whole plant cannabis might do one thing versus THC isolated versus CBD isolated, but we just don't have the data on the whole plant cannabis and what it can do.
Okay, thank you. And I lied. I have one more
All
quick
right.
question.
Well, we're going to take that and one other question, and then we're
Okay.
going to move on so we can have time for the rest of the presentation.
I know that we've heard a lot about data and studies coming out of other countries. Can you comment about some of those studies and whether or not it would be advantageous for, you know, a research center to really take into account some of those studies and conduct our own? Do you have an opinion about some of the studies that have been done outside of the U.S.?
Sure. So Israel is probably the leader in medical cannabis research. They have initiatives in place and dollars set aside to really fund a huge portfolio of research. Some of the issues with the data coming out of Israel is that not all the studies are well controlled, meaning they don't always have a placebo control. They don't always look at several doses. They're just looking at one. And so some of the data are controlled though, and it's really valuable. It's giving the rest of the world a signal of what's going on and what we should be picking up on. So I think a lot of the studies are really valuable. They don't hold the weight for various reasons to be able to take that data to the FDA and get full approval for cannabis for any given condition. But I think it can give us a lead of what we should be looking at here in the United States. But I think Israel is probably the best example that we can use. And not all of their studies are promising. So some of the studies are having negative results. Others are having promising results. They just came out with a study looking at THC and CBD solutions for autism spectrum disorder with some exciting results. But the sample size and some of the other conditions weren't ideal. And so that would be something that we could replicate in the United States and at UK if the initiative was there and the expertise was there to do it.
Thank you so much.
We have one other, and then I'm going to move forward. So, Senator Turner, you had a question?
Thank you, Mr. Chairman, and thank you, ma'am. You used the word about, in an answer to a question about testing, and used the word long time. Could you please define that for us legislators so we'll know what a long time? Thank you very much.
I'm not sure what you're referring to. I'm sorry.
I apologize. Somebody asked you about the testing for the future, the clinical trials, and you used the word long time. And I just don't, I want to know what you meant by long time. Well, that's months, years?
Years and years.
Okay. All right.
So the public interest and the public uptake of cannabinoids has far outpaced the science and the addiction science. And so the medical and scientific community is playing catch up constantly at every avenue, at every juncture. So medical cannabis has kind of exploded in the past few years, but the scientific research has not followed suit. And so we're always lagging behind. But we are trying to find, at least at UK, the most important questions to ask to try to move the field forward and try to understand it better, what people are doing and what people are taking.
And I apologize, but I've listened to what you said, and I did understand you said that there are some places, though, where it is beneficial to certain people.
It is.
All right. Thank you, Mr. Chairman. That's all I have. Thank you, ma'am.
Thank you, Doctor. You're certainly welcome to stay tuned for the out of the presentation. There may be other questions at the end of that. I'm certainly going to give Representative Nemes time to present his matter. Again, we don't have to be out of this room by 1, so we're going to proceed. If you're welcome to stay with us. With that, though, I am going to start with some preparatory comments by my friend, Chairman Westerfield.
Thank you, Chairman. I just wanted to give thanks to Representative Nemes. Last year, after the bill died of COVID, along with a lot of other bills in 2020, as soon as session ended, I reached out to Representative Nemes and Senator West as the primary sponsors of this bill. Knowing that some version of this was going to keep coming back, I wanted to reach out and talk about some of the issues that I had and that others had raised in the bill. We didn't get to work on that much in 2020. In 2021, everything was put on hold because of COVID. And so while the bills were filed, they weren't even referred. But I reached out again. And to his credit, Representative Nemes responded. And we've been working for several months now, having a number of meetings, just Jason and me and Chris Joffrian on staff, the analyst and drafter. And we have worked through literally every section of the bill. Now, we've got a punch list. Now, don't do that, Senator Berg. I don't know if I'm going to vote for it or not, and I've told Representative Nemes that. But I'm a lot closer to being able to support something based on what we've worked through, and I wanted to thank you for that. I didn't make that public until just now. He didn't either. I wanted to have a meaningful discussion about all the various parts in the bill, and there have been a number of improvements and updates and changes to it, really that we both agreed on. We'll finish going through that punch list here in the next couple of weeks, but I expect to see the bill in 22 filed. I don't know if it's going to come to me. It's come to my committee. It's come to other committees before, but I wanted to thank Representative Nemes for working with me on it over the course of the last several months. Thank you.
With that, Representative Nemes, you have the floor.
Well, I'll start by saying I thank the Chairman Westerfield, for those remarks and his diligent review of the bill. We have went it section by section, line by line at sometimes, and we have a few things more to do, and the bill has improved because of it. We've tightened the rules on caregivers and a number of other things to improve the bill, and I very much appreciate that. I also want to invite Chairman Westerfield to say yes. When I ran for office, I was against medical marijuana. I was against marijuana. I've never used it in my life. I thought people who used it were unambitious. If I used it, you guys know a guy named Mike Nemes, Senator Mike Nemes. I'd got a whooping from Mike Nemes. I have 3 sons. I have no interest in them going down the path of drugs and marijuana or anything of that nature. I've never used it, never intend to use it. But I know beyond a shadow of doubt, and so does every person up there, that it helps people. There's no doubt about it. Senator Robert Stiver said on KET a few years ago, there's no doubt about it that it helps people. The Academies of Science and Engineering and Medicine, they say it helps people. There are plenty of studies that say it helps folks. We need some more, no doubt, but it does. So what I want to do today is, we're not going to have the glitz and the glamour that we normally have. I don't have families here with me to talk about it. I want you guys to know, and ladies, to know what's in this bill. This is the most responsible bill, the most protective bill of public safety that you can have, that will be in the whole country. So I want you to be able to go back to your constituents and say, I support medical marijuana Kentucky style, the way that it's protective of our public safety and the way that it's protective of folks who need it. And we're going to try to get it to people in connection with their physician. I don't think it's appropriate to have a hearing like this without my good friend Eric Crawford saying a few words. Eric's been involved, as many other advocates have been, for many years. So, Mr. Chairman, if I can, he's with us today virtually. I'm going to ask Mr. Crawford to start us off, and then what I'm going to do is go through the bill, and no glitz and glamour. I want you to know what's in the sections, and then I'm going to tell you why I was against the bill, my particular objections, and why I don't think they hold water anymore, and I think you should join me in saying yes. Even my good friend Kim Mosier should say yes to this bill. If we care about Kentuckians, we will join the 65 representatives who voted for it in 2020, on February 20, 2020. This is the right thing for Kentucky. There's no doubt about it. If I can call on Eric Crawford.
Absolutely. Is it Crawford? Mr. Crawford, are you there?
Chairman Westerfield, Chairman Massey.
Make sure they can hear you.
Thank you for giving me this opportunity to join you today from my home. I am grateful for this option. Thank you both for allowing me to speak about medical cannabis in your committee. Thank you, committee members, for hearing me today. My name is Eric Crawford. I'm a lifelong resident of Mason County. I was born, raised, and live in Orangeburg, Kentucky. I am rooted in Kentucky. This is my home. I love Kentucky. I am part of Kentucky, and Kentucky is a part of me. 27 years ago, at the age of 22, I was a passenger in an automobile accident that left me a quadriplegic. also suffer with an autoimmune disorder called optical uveitis, which may ultimately lead to blindness. I am a disabled and sick Kentuckian. I'm often viewed as a criminal in the state that I love. Medical cannabis is legal in 37 states. We're not inventing no wheel. The vast majority of Americans have legal access to medical cannabis. Because of my accident, I am confined to this wheelchair and require around-the-clock care. I suffer with constant nerve pain, ungodly muscle spasms, extreme stiffness, arthritis, and chronic urinary tract infections. Life in this wheelchair is not easy for me nor my family. Being physically disabled is not a life I wish for anyone. If I choose to use cannabis as my medicine instead of the addictive opioids and other dangerous legal pharmaceuticals for my pain and spasms, I am seen as a criminal in the state that I love. Opioids make me out of my mind. They don't help my everyday pain, they make it worse. They make me high and unable to function at all. I've only taken one single opioid in 8 years. If I would have stayed on the legal drugs that the doctors had to offer me for my pain and spasms, I would most likely be dead or my life in shambles. Cannabis can work better for me than what my doctors have to offer. Cannabis allows me to get out of bed and make the most out of life. My eye doctors recommend cannabis for my complicated vision issues. My autoimmune disease causes my vision to be very distorted. It causes major inflammation in the veins of my eyes. The FDA-approved drugs I have to take to control my optical uveitis has caused uncontrollable glaucoma. I am prescribed 3 different eye drops to control my glaucoma, including latanoprost, Cosop, and bromamidine. My pressure isn't controlled by pharmaceuticals alone. It is imperative that I keep my eye pressure controlled. Cannabis reduces inflammation and lowers eye pressure. Cannabis is a self-preservation tool for the longevity and better of my life and other sick Kentucky people. All my well-respected Kentucky physicians recommend and totally support me using cannabis to treat my many ailments. But again, if I use it, I am a criminal in this state of Kentucky. If Representative Nemes's medical cannabis bill were to pass and become law, I would not be a criminal. I would not have to lay awake at night and worry about law enforcement. I could relax and concentrate on my health. My poor wife and mother could relax too. Living scared is not healthy. I just want to feel better. If medical cannabis was legal in Kentucky, I would have safe access to legal cannabis. As patients, we don't want to be viewed as criminals, nor should we. Please know I'm not the only sick person in Kentucky that is in this predicament. There are thousands and thousands of ill people in our state that use cannabis medicinally that are considered lawbreakers. You really think sick people you think people seeking help from medicine are lawbreakers? We are sick people desperately seeking help. Needing medicine and needing help from others is not fun. Needing medicine isn't fun. We don't want to be sick. We just want to feel better. We need you to change the law to allow medical cannabis for patients if their doctor recommends it. Please help us. There is a 24.8% reduction in overdose deaths in states with legal medical cannabis. That is done by the Journal of the American Medical Association. Not me. That is 1 out of 4 people that would be alive today in this bluegrass state of Kentucky. One person dies every 19 minutes from an FDA-approved drug, according to the Center for Disease Control. Not me. Not one single death has ever been attributed to cannabis use. What would you do if you had a lifelong illness and cannabis helped you? What would you do if your baby or grandbaby had a rare seizure disorder and children from other states with the same disorder were doing better because of medical cannabis? What are you going to tell the veteran that suffers from combat-related injuries who fought for our country who gets help from cannabis? Would you tell them to move to the other 37 states that allow patients the option of using medical cannabis? Would you advise them to obtain illegal cannabis and pray to God they don't get caught with it? Would you be a criminal if you were sick? I am here today on behalf of myself and many, many other sick people and disabled Kentuckians to ask each of you on this committee to stand up and do the right thing. It's your moral duty to help those less fortunate than you are. It's your job to enact laws for the betterment of all Kentuckians. It's your job to help sick people. I am asking this committee to stand up and do the right thing. Step up this coming session and pass medical cannabis because there are so many desperate Kentuckians that would benefit. We shouldn't have to fight anymore just to feel better. Please do the right thing and help us. Thank you. And about your studies, we got the LaGuardia report that explains the science they used in 1937 was false. Also, from 1937 to 1968, glaucoma and cancer patients were allowed to be prescribed medical cannabis. Court case stopped in 1968 and 1970. They said it was no good for medical use. So we got the studies, we've got the use. Let's get this legal for sick people in Kentucky and do something about it. Help us, please. Thank you for your time.
Thank you, Eric. You know, he got a little hot at the end, and I think he's entitled to that. And I want to say thank you once again, Mr. Chairman, for allowing me this opportunity. I know it's late. It's already after the committee was supposed to end. I regret that even though the House passed it 65-7, and I'm not making any allegations here. I know people have tough calendars. I do regret that half of the senators that were here earlier had to leave because they had other obligations. But I think this is important enough to Kentucky, thousands and thousands of our citizens, of our constituents, that I do what I need to do, and that's to go through the bill. So we put on the record and put in the minds of senators and hopefully other people watch how responsible this bill is. So I'll try to be quick, but I think I need to go through the bill. May I do so, Mr. Chairman?
You may proceed.
Thank you. And I also want to thank Dr. Babylonis for being here. I do very much appreciate her comments. I disagree with a lot of them, but I also agree with some testimony she gave or some presentations she's given before. I was notified yesterday she was going to testify, and I went back and I looked at some things, and she's mentioned a number of times that cannabis does not produce overdose or deaths in adults. That's off the table. That's clear. There's no doubt about it. And so I appreciate her.
That's absolutely true. That's absolutely true.
Right. Thank you. And you've said that a number of times, and I appreciate you saying that. Okay, so here's what I want to do. I want to go through the bill, and then I want to say what some objections I had. I'll be relatively quick. And who's for it? KCO's for it. League of Cities is for it. KEA, Joint Executive Council on Veteran Organizations, Council for Disability Development Disorders, KJA, Multiple Sclerosis Society, the Kentucky Nurses Association, Senator Rand Paul, a number of other people. I can't go through the counties and cities that have adopted resolutions supporting it because they're too numerous, and we don't have time to do that. What is not in this bill? This bill is no smoke. I hear a lot of people beat up on the bill because they're going to folks saying smoke, smoke, smoke. This bill's no smoke. This bill has no self-grow. I've taken some things out of the bill that I think should be in it in order to get it passed. But it does not have smoke. It does not have self-grow. The big picture, before I get into particulars, you have to have a bona fide relationship with a physician or an APRN who's authorized to prescribe controlled substances. It's not everybody. It's a physician or APRN. You have to have a qualifying condition. We've noted 4 qualifying conditions. It's not wide open. There is local control. So once this bill passes, and I'm confident it will, if given a vote, I know it will, Once this vote passes, there's local control to take it off the books if a particular county or city doesn't want it. There's cultivators, there's processors, there's dispensaries, there's safety compliance facilities, and voluminous rules that apply to each of them. It goes into the Department of Health, not the Alcohol Beverage Control. It requires a pharmacist's approval, annual approval. From the beginning, in-person visit with the pharmacist, and continuous by telehealth, and they have to be annual visit at least once a year. The information goes into Casper, so folks can see it. All the players can see it, including law enforcement. And it's not taxed, because we don't tax medicines in Kentucky. It's taxed at the excise level like we do other medicines, but it's not taxed at the point of sale. Section 1 has definitions, including what a bona fide relationship is and what practitioners are. There are a number of definitions. Just want to go through these. I'm not going to go into particulars on what's in these because of time. Section 2 gives legal protections for all participants, practitioners, card holders, physicians, attorneys, pharmacists, and everyone else, so long as they're complying with the provisions of the Act. Section 3 allows the Department of Public Health to regulate and tells them what to do, how to go through the accreditation process. It sets up a board. The board has 8 doctors and APRNs appointed by the governor. They have to have expertise in particular enumerated areas, has 1 pharmacist and 6 patient advocates. Annual report to the General Assembly. That annual report is mighty robust, so we can make sure that we're doing what we need to do. We'll know the profits of every business involved. We'll know how many people are getting this. We'll know what conditions they're getting it for. Of course, only 4 are qualified, by the way. Section 4 has purchase and possession limits. You can only have 30 days limit at one time, 10 days on your person unless you're transporting it home. It has to be in a sealed package, 2-step opening process. That's the best what we found in other states, so we've taken it and made it Kentucky's. A minor may only use it if they have a caregiver. A caregiver has to be a parent or has to be a legal guardian. Cannot be just anyone. And a caregiver can only have a maximum of 3 people in their care. Caregivers do not get paid like they do in other guardianship proceedings. Senator West, as you know, they only get reimbursed here. There's no profit motive for a caregiver. We're trying to remove all of the incentives to misbehave here. Section 5 has due process for card holders. If you're a card holder and you go through the process, you do not waive your constitutional rights. So people cannot come into your home just because you're a card holder and have a presumption that you're a lawbreaker. You're a sick person, as your physician says that you're trying to be better. Section 6 is the restrictions on cannabis use. You cannot operate a car. You cannot operate a car. So all the stuff that we were talking about earlier on that, you can't operate a car as you can't now on marijuana or alcohol or any of the other things that we talk about. You cannot possess it on school grounds, in the jails, or on federal property. If you violate, what's going to happen? You're going to lose your card, and you're subject to prosecution. This bill ain't no joke. We're talking about medical cannabis. We're talking about helping people who need help. We're not talking about making it available willy-nilly. Section 7, after talking with the Chamber of Commerce, it talks about employer rights. Employers, I don't like this. Employers are not required to allow their employees to have medical cannabis. They can terminate them for that purpose. I thought it should be used the same as every other thing, opioids, which are much more dangerous. But in order to get the bill vote on in the House and to get it passed, we have allowed employers to have their own rules, including not allowing their employees to have a card and be a patient in getting medical cannabis. Section 8 talks about the patients have the same rights as any other citizen, so the fact that you're a card holder cannot be used against you in a custody proceeding. It cannot be used against you for a landlord. Folks have a right to be housed. Folks have a right to their kids. Section 9 establishes the authorization process for physicians and what their responsibilities are. If you want to be a physician or if you want to be an APRN that recommends this, you have to apply from your licensing board, the Kentucky Board of Nursing and the Kentucky Board of Medical Licensure. I practice law in front of those 2 boards all the time. Highly responsible, respected people. Not just anybody can get it. So if a doctor wants to participate and the Kentucky Board of Medical Licensure thinks, nah, not this one, they can stop it. If one does get approved and later needs to be unapproved, it's an annual re-registration. So it allows the professional boards that we put so much trust in to regulate who is allowed to be in it. The patient must submit an application to the Department of Health. The card has the name, the effective date, photo, and a bunch of other very important information. Section 15 talks about revoking cards for people not following the rules, and specifically allows for criminal prosecution, the same as existing law. So if someone is acting like they're a card holder, but they're using it for recreational purposes, this bill's not designed to protect them, and it does not. Section 16 deals with business licenses for all cannabis businesses, has the fees and the fines and all the rules that they need more globally. Section 17 talks about the business application process, which is very specific and telling what the department has to consider. Section 18 is the approval process for the number of businesses. They have 45 days to approve or deny a particular application. We're not allowing a bunch of these things all over the place. It's only what the market would bear. So it's akin to what we have as a certificate of need, Senator Turner, which you know a lot about for hospitals and adult care facilities. If there's a proliferation, there will not be a proliferation is the point. There must be, to make sure there's enough, 15 cultivators, farmers, 25 dispensaries throughout the state, at least five processors and 3 producers. A producer is a combination of a cultivator and a dispensary, because we're allowing a company to have both of those licenses if they qualify. Section 19 talks about general business requirements, that you have to look at the criminal history of everybody involved, all owners, all investors of all of these businesses. You're not allowed to be a physician and have any financial interest in any of these businesses. You cannot locate nor possess any of this near a school. It talks about who can and cannot be even on their boards, even if they're not investors. Section 20 talks about how to revoke business licenses. Just like the physician and like the patient, these businesses must behave. If they don't behave, they'll lose their license, and their principals should be and will be prosecuted. This bill ain't no joke. This is a medical bill designed to help people who need it for medical reasons. This is a tough bill, Senator Turner. You can go back home and let's tell our people how tight this thing is. Section 20, like I was saying, how to revoke licenses. Note it, and if you revoke a license, Senator Wheeler, it gives the right to notice, processed, and right to be heard, as we have all over Kentucky law. Section 21 deals with cultivator specifics. It sets up the tiers based on how big you are. If you want to be a smaller operation, or if you want to be a larger operation, your fees will be different. Section 22 deals with specifics about dispensaries. You must have a collaborative agreement with the pharmacy. I think that's something that we've put in the House. We have 5 people, 4 pharmacists in the House, and one who is involved in a pharmacy, and they understand how important this is, and I agree how important to have a pharmacist at the table is. So any dispensary has to have a collaborative agreement with a pharmacy. Section 23 deals with processor specifics, very detailed. Section 25 deals with producer specifics. Section 24. Section 25 deals with the safety compliance. And I said you can have some of the licenses, of multiple licenses. If you're a safety tester, compliance tester, you cannot have any other license or have any other role or interest in the medical cannabis world. You have to only test the product to make sure it's safe. I'm on 25, there are 42, but like 10 of them are combined because it's all right. Section 26, local governments may prohibit or submit the question to voters, which I think is very interesting. So once we pass this bill, it'll be legal across Kentucky. If there's a particular, I'm going to use my own county. If Oldham County decides that they don't want it in a particular area, Crestwood can vote to allow it. Or if Oldham County decides the magistrates, they won't do this, by the way, I've talked to them, but if they decide, hey, I don't know, let's put it to the people and let them decide, then they can make a referendum, as we do, wet dry votes. But it's legal everywhere with the opportunity to take it away. And if a particular county takes it away, a city can allow it in their jurisdiction. Section 27 deals with data maintenance to make sure all the players know everything going on, including law enforcement. Section 28, department regulates, it says what the department must regulate and provides a system to monitor the program, as I said, for all the participants. Section 29, there's no third-party payor. That's unfortunate. So there's no insurer doesn't cover this. Medicaid doesn't cover this. That's very unfortunate. We try to, one of the reasons that I'm so strongly for this is for indigent folks, and I'll get to that in just a moment because we have a section to try to have access for people who are indigent. Section 30 exempts medical cannabis from excise tax on controlled substances. No taxing there. We tax it in a different way in just a moment. I'm getting to that right now. Section 31 creates a state trust fund. The state trust fund is on the fees and the fines and the penalties of all the businesses that are involved. 60% goes to the Department of Health to administer the program. 2.5% goes to grants and education for research. 13.75% goes to law enforcement. 13.75 goes to indigent access. And then the remaining 10% goes to the Department of Health if they need more than the original 60% they get. If they don't, and I'm hoping they don't, if they don't, it goes to provide more access to indigent care. Section 33 provides a local trust fund. I just talked about the state trust fund. There's also a local trust fund that goes to law enforcement and to local cities and counties to make sure that they cover their costs of ensuring that we have the right apparatus in place for public safety. Section 33 establishes the excise tax for medical cannabis, 12% on the profits of the cultivator and processor. 80% of that goes to the state trust fund. 20% of that goes to the local trust fund. The dispensary is not taxed. Point of sale not taxed. We don't do that with medicine. In Kentucky, we keep that. Sections 34 to 42 are conforming language. That's the bill, Mr. Chairman. Couple quick remarks in addition to that. We took the best parts from other states, from Oklahoma, from Colorado, from Connecticut, from all the states, and we made the Kentucky version. This is the tightest version, much tighter than I want it to be, but I think it's a tight version that I think we can get past. My objections. When I first ran for office, I objected. I was against this. I met with a group of people at Crestwood Library, and I had all these brilliant reasons why I was against it, and I was going through them. And I thought I had to meet with them. I knew we differed, but I thought it was my responsibility to look them in the eye and talk to them. There are 8 of them. They look just like us. They weren't folks just trying to get high or trying to get by some kind of a rule. They wanted to be better. They wanted to feel better. And as I was giving my reasons, one of them leaned forward. I'll never forget it. Touched my hand and said, "Jason, listen to me for a second. Let me tell you what it means to my child." I'll never forget it. I wasn't convinced, but I knew that I had a question, and I went back and I studied. I talked to physicians in my district. The overwhelming majority of the physicians I talked to supported medical cannabis, provided we had the right bill. When I turned my position, I said, I'm going to make the right bill. We already had a really good one. Senator John, my mind is blank here. He's my good friend. John Sims, hello, from Fleming County. John Sims had a wonderful bill. He and I improved this thing together with Senator West and some others. So the objections I had were banking. How can you bank? Well, according to the Department of Treasury, 559 banks across the country provide this access, and over 180 credit unions. Banking's not an issue. What about the slippery slope? I don't want this stuff for my people. Well, let's not kid ourselves. We're not bringing marijuana to Kentucky with this bill. Okay, let's not be silly. What we're doing though is we're bringing tested products to Kentucky. We're letting mom go get products for her child. We're letting dad get it for his wife at a place where the lights are bright and the products have been tested. They don't have to go to the alley and get it from a trafficker, which is fentanyl involved in there, Senator Hebron? Representative Hebron, I don't know. Is fentanyl there? It won't be in this product. We're not bringing marijuana to Kentucky. We're bringing clean, good, tested, safe marijuana to Kentucky. Does it really help folks? Nobody can say with a straight face it doesn't. I'm not here to tell you it cures the world's problems, but there's nobody here that can tell you it doesn't help folk. Nobody. The biggest problem I had, because I'm a lawyer, is it violates federal law. I can't be for something that violates federal law. Well, so I looked up. I got into that a little bit. There's something I want you guys to follow me up on this. Make sure I'm not joking, because I didn't believe it at first. There's something called the Rohrabacher-Farr Amendment, which has been put on all the federal budgets since 2014. And it says that no federal dollars can be used to enforce federal prohibitions against marijuana in states that have medical marijuana programs. You know what's interesting? They list 33 states. At the beginning, they list 33 states. One of them was Kentucky. Federal government considers Kentucky to be violative of the federal Schedule 1 because we have the CBD. It says none of the funds made available in this act to the Department of Justice may be used with respect to the states of Alabama, list a bunch of them, including Kentucky, to prevent such states from implementing their own state laws that authorize the use, distribution, possession, or cultivation of medical marijuana. Congress, the United States Congress, has passed that into every budget since 2014, including the current one, that says we're not going to prosecute, we're not going to enforce federal law in states that have medical marijuana programs. I'm going to end with a quick story and I'm done. I was campaigning in 2018. After I changed my position, I was worried I was in front of my skis, over my skis. But I was campaigning, going door to door as we do. And I went to this fella's house who was 85 years old. You have your sheet. I'm sure the Democrats have it too. Republicans, we have our sheet. We have our database. And I know how many registered voters are in the house. There was one man, 85-year-old man, Republican, knock on the door. He answers. I say, hey, my name is Jason Nemus. I'm your state representative, running for re-election. I was doing the pitch. He stopped me in the middle of the pitch. And he said, aren't you that fella pushing marijuana? And I thought, oh, man, he's about 6'4", 85. He could put me down if he wanted to. So I got probably kind of bowed up a little bit, got ready for my argument. And I said, well, yes, sir. And I was starting to defend myself. And I'm not going to tell you he started tearing up, Representative Massey. I'm going to tell you he started bawling. This man started bawling in front of his representative who he'd never met before. And I said, what's on your mind, buddy? What's on your mind? And he pointed to a couch. He said, my wife just died. Died of cancer. She couldn't get off the couch because she was so nauseous. We got 2 sons, and they provided medical marijuana to their mom. Jason, we don't break the law. It's not who we are. But that allowed my wife to get off the couch. It allowed her to live at the end of her life. Mr. Chairman, there are questions around this subject, but this is an unqualified good for our people. I hope we get a vote. It passed 65-30 in the House. It will pass with similar percentages in the Senate. I request a vote. If you're against it, I respect you. Vote no, but let's vote. This is good for our people. Thank you, Mr. Chairman.
Thank you, Representative Nemus. I'm going to say that I know several people had signed up to speak today. We're not going to have time for that, and I do apologize. If your question was not addressed, you can address that to your respective senator or representative and get that to us, and we will try to get you answers to those questions. We had the people that signed up and their phone numbers, et cetera, so we will try to do that. We do have a few people that have asked for questions, and I know that some people may have to leave, but we do have Senator Turner. Do you still have your question?
No, sir.
You got it answered? Yes. All right. We had Representative Mosier.
Thank you, Mr. Chair, and thank you, Representative Nemus. I really do appreciate all your work on this. I know that you've worked really hard to tighten this, and for the record, I just want to say, I am for decriminalizing possession of marijuana. I'm for lifting marijuana from the DEA list of Schedule I drugs for research. I am for ensuring that patients have safe medication, and Eric, thank you very much for being, always presenting your side, because I think it is important that we understand what patients are going through, and I greatly appreciate your work. We know that half of Ohio, the population of Ohio now qualifies for a medical card, and that just kind of defies logic and common sense. So I appreciate your work at really limiting what this bill actually does. And I can say that we're a lot closer than we were several years ago. My question is around, I thought that you had a research component in this bill, and I didn't see it in this. So if you could just explain what the research piece of this bill is, I would appreciate it.
Thank you, Mr. Chairman. Thank you, Representative Moser. It is in that's covered in section, sorry, I had to row so fast. That's covered in section 31 of the bill. It goes to the Department of Public Health for the purpose of research, further education, scientific, and clinical research. Right. So that's in section 31 of the bill.
Okay. I'd like to talk to you more about that piece. And, I'm just concerned also that we're creating a huge government bureaucracy. We don't really know the fiscal impact. There are 39 statutory changes in this bill. There are 35 regulatory changes in this bill. That's a lot. We have trouble with some of the bills that we pass, even getting a couple of changes implemented. So I'm curious about how that's going to happen. So, some folks would just say, why not just legalize marijuana recreationally? What do you say to that?
I don't support that. We don't have the votes for that in the General Assembly. This is the medical marijuana bill. This is not recreational bill. This is what we have the votes for. There's no doubt about it. We have the votes for it in the House and the Senate. It passed 65 to 30 in the House. We were told it wouldn't get a vote. It wouldn't pass. 65 to 30 in the House. We have the votes. We need to have the courage to vote. So the votes aren't there for recreational marijuana. I wouldn't support it. I don't know where you would be on that question. That's not what this is about. This is about people like Eric. This is about people like that man's wife that I talked about. This is about, I can't walk the hallways at LRC. Let me tell the truth. I can't walk the hallways at LRC without LRC employees coming up to me, many of them crying, saying, thank you, thank you, thank you. Some afraid to lose their jobs, right here working for us. Some afraid to lose their jobs, tell me about themselves and their families. And I'm fighting for them, and I'm not fighting for the world. That's somebody else's fight. My fight is medical marijuana, and if I get a vote, it will be won. There's no question about it.
Okay, just one last quick point. Other states that we've seen legalize medicinal marijuana, the average length of time that it takes to go from medical to recreational is about 2 years. Are there any states who have medical marijuana that haven't gone rec?
There are plenty of them. There are 36 states that have 36 to 37 states that have medical marijuana, depending on what you do with D.C. Obviously, it's not a state, but so 36 states in D.C. have medical marijuana. There are a number of them that do not have recreational marijuana. And let me just say this: in order for us to have recreational marijuana in Kentucky, it requires a vote of the General Assembly. You know our colleagues, not in the cards. So I don't know. I people bring this up, but it's a complete red herring. It cannot be unless we vote for it. This is not a recreational bill. This is a medical marijuana bill, and that's my answer.
All right. Thank you.
Thank you. We're going to be very quick because I will tell you, though, the reason we went longer is because we had about 20 to 30 minutes of technical difficulties. So to keep within our limit, let's speed this along. Representative Heverin.
Thank you, Chairman. First off, I would like to acknowledge a constituent from the 18th District on the front row, Julie Cantwell. She's been a big advocate for this since I've gotten into office. Truly, though, I generally wouldn't do this, but I want to commend Representative Nemes on his civility and persistence on this issue. He's taken a lot of time to educate members and build bridges to encourage support for this policy. In 2019, when I ran for this office, this was a very big topic in my election campaign. And I didn't really know how I felt about it. And I had a lot of people from my district educating me. I met with baby Colby and her mom, Alex, to hear more firsthand of what it was like to have a child that needed this. And, I was very similar to Representative Nemes. I didn't want to go down a hole of doing recreational marijuana. But he really took time to meet with me, and people in my district took time to meet with me to educate me on this issue. And I listened. I remembered that I am the voice of the 18th District. I'm not here to be Samara Heverin. And on a personal level, I do support medical marijuana. But as the 18th District, as I listen to my people, they support that. Our Grayson County Fiscal Court supported a resolution in support of baby Colby. And as my job here as a legislator, I felt that's what I needed to do. And so in 2020, I was proud to vote yes for the 18th District on House Bill 136. In 2021, I became a co-sponsor for the legislation because I think it's that important that I put my name on it and the people of the 18th District's name on it to represent this and to do what's right for the people. As we go into the next session in 2022, I look forward to hopefully voting on this measure. But I really want to encourage two things. I want to encourage civility among the advocates, and I want to encourage members to be open-minded on this conversation. Go in with an open mind and be willing to change your mind. But for the advocates, I encourage you to be kind as well. I know you've been fighting a long time for this, but kindness wins every single day, and that's something we need to learn more about in politics. And so I encourage you, if we can be helpful, please let us know. I know that we're always talking to other members about legislation that we're supportive of, but you all really do have a champion in Representative Jason Nemes in this bill. And he puts up a big fight and he doesn't back down, and I really respect that about him. Thank you, Chairman.
Thank you.
We have two more. Okay. Representative or Senator Berg and Representative Banta.
I just want to make sure I heard you correctly because this is important to me. The marijuana would be grown in Kentucky.
All of it.
All of it.
Yes, ma'am.
Thank you.
Chairman, last
closing remark.
I'm gonna close with a question. This is about baby Colby. This is about other people. If your child needed this, and if your child's physician said that it would be helpful, what would you do? What we do in Kentucky right now is we say, get out of here, or put yourself in a position where you might go to jail. That's not appropriate. I know what I would do, and I know what you would do. So let's make the laws allow that decision, because every one of us would go and help our kid. So that's the question. This is the bill to get it done. So join me and let's get this thing passed. Thank you, Mr. Chairman.
Thank you very much. Thank everyone for their patience dealing with our technical problems. That's what you have when you live in a time of COVID. We apologize for that, but thank you for your attentiveness. We stand adjourned.
Red.